That we are live, and now we are being streamed live on YouTube. This is the Health Coverage Insurance and Financial Services Committee, and my apologies for our tardy start this morning. And we are here for a number of work sessions today. As I've mentioned, we will be taking a break at 11:45 and reconvening at 1 p.m. for our work today. We will be taking up 11:96 after lunch. So if you're here for that, you can rejoin us after the lunch break at 1 p.m. Okay, so we will begin with committee introductions, starting with Representative Arford.
Thank you, Madam Chair, and still good morning, almost good afternoon, but I am Representative Poppy Arford and I serve District 49, the western part of Brunswick.
And Representative Evans.
Thank you, Madam Chair. I am Richard Evans. I represent House District 120, including the towns of Atkinson, Brownville, Dover, Foxcroft, Medford, Milo, Barneville Township, and Lakeview Plantation.
Representative Matheson.
Thank you, Madam Chair. My name is Christy Matheson. I represent District 1, Kittery.
And Representative Blyer. Oh.
Yep. Thank you, Madam Chair. My name is Mark Blyer. I represent District 22, which is Leamington and part of Buxton, Standish, and Limerick.
Representative Quint, I didn't see you up there in the corner of my screen. Go ahead.
Hello, my name is Tracy Quint. I represent House District 144, including the towns of Benedicta and Amity.
Representative Melorano.
Good morning, I'm Gina Melorano. I represent House District 62, which is part of Auburn.
Representative Brooks.
Thank you, Chair Sanborn. My name is Heidi Brooks. I represent House District 61, which is part of Lewiston.
Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent House District 75, which is Turner, Leeds, and Livermore.
Senator Stewart.
Morning, folks. I'm Trey Stewart, State Senator in District 2, which is 51 communities in Aroostook and Penobscot counties, and I reside in Prescott.
And Representative Tepler.
Good morning. My name is Denise Tepler. I represent House District number 54, which is all of the terrific town of Topsom, and I serve as House co-chair of the committee.
And I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And we're assisted today by Ed McCaford, our committee clerk, and Colleen McCarthy-Reed in our OPLA analyst. And we're going to start with LD 482, an act regarding pet insurance. And I'm going to have Colleen present her bill analysis for us.
Okay, here you go. LD 482 is an act regarding pet insurance. Let's make it a little bigger. The bill was originally introduced as a concept draft, and carried over from the first regular session. Senator Sanborn proposed an amendment to the bill which would replace the concept draft and enact requirements for the sale of pet insurance in the state. And it uses the most recent model from the National Association of Insurance Commissioners. They've been working since, I think, 2019 on a proposed model draft. That process is ongoing, although they have not yet adopted the final version of the model. The version that the draft amendment reflects is their most recent draft that will be discussed further at the upcoming meeting of the NAIC in April. The bill's requirements would apply to pet insurance policies issued to residents of Maine, to policies that are sold, solicited, negotiated, or offered in Maine, and to policies and certificates delivered or issued for delivery in Maine. It defines specific terms related to pet insurance, like pre-existing condition and wellness program. It would require insurers to make specific disclosures to consumers about the terms and conditions of the pet insurance policy that they purchase, describe how claims are paid, and would also give policyholders the right to return a policy within 15 days. The bill does permit exclusions for pre-existing conditions under these policies as long as they are specifically disclosed to consumers. With regard to waiting periods, the bill also does allow a waiting period under the policies for illnesses or orthopedic conditions, but not accidents. And the waiting period that's permitted cannot exceed 30 days. An insurer must waive a waiting period if the covered pet undergoes a medical examination paid for by the policyholder. And then lastly, it contains some provisions related to marketing and sales practices. The bill would prohibit insurers and insurance producers from marketing wellness programs as insurance and marketing wellness programs while selling, soliciting, or negotiating pet insurance. It also requires insurance producers to undergo training before selling this type of insurance. As I mentioned, the bill proposes a specific regulatory framework for pet insurance. Under current law, to the extent that pet insurance is regulated, it's regulated as property insurance. And what the bill proposes to do is establish a chapter in the insurance code that covers and is specific to pet insurance. As I mentioned, the draft reflects the latest draft being considered for adoption by the NAIC. And it's my understanding that there is California is the one state that has enacted or had previously enacted legislation related to pet insurance, and that in part prompted some of the discussions at the NAIC level, in addition to sort of the expansion of the availability of pet insurance throughout the states. The focus of the testimony that you received really was on two provisions of the bill and suggested that the committee think about making further changes to the proposed draft. You had testimony from both the North American Pet Insurance Association and APCIA, the American Property Casualty Insurance Association, asking you to consider two further changes to the bill. The first relates to the waiting period provisions and suggests that you remove the language in the draft that establishes the maximum waiting period is 30 days and that prohibits a waiting period for illnesses or orthopedic conditions resulting from an accident. The second change they asked you to consider is removing the language that would prohibit an insurer or insurance producer from marketing a wellness program at the same time or during a sale, the sales solicitation or negotiation of pet insurance. Two additional things to mention: the bill as drafted would authorize the superintendent of insurance to adopt rules as necessary to implement the requirements of the chapter. The bill draft designates those rules as routine technical. If the committee is interested in requiring legislative approval before any rules can finally be adopted, you might consider changing that designation to major substantive. And then the last thing I would note is the draft amendment as proposed does not include a specific effective date for the statutory requirements. And I don't know if the committee might want to consider a specific date such as January 1 of 2023 to allow some additional time for insurers to comply with the requirements and any sort of form filing or other requirements that would be required as part of the regulation by the Bureau of Insurance. You don't yet have any fiscal information about the bill. I guess I will stop there. I'm happy to answer any questions. I know you have folks here from the Bureau and other representatives in the attendee space. I did hear back from Mr. Bernier, who represents insurance producers, and the committee had asked for some additional feedback from insurance producers about sort of their practices or the sales of wellness programs in conjunction with pet insurance. And he reported back that he really wasn't able to get any specific feedback as it's been a fairly new product for his members of his association in terms of offering and the sale of this type of product. So I'm not sure, I'm not sure if I saw that he was here, but I wanted to pass that along to you as well.
Thanks, Colleen. Are there any questions for Colleen? Okay, so I guess I would just start by saying that with regard to the waiting period discussion, I'm hopeful that the committee will follow the NAIC model. These discussions about accident waiting periods and illness waiting periods were all hashed out at the NAIC level, and the Model Act, I think, represents the consensus of that group with regard to the waiting periods. This isn't one of the outstanding issues. It's one of the sort of resolved issues, is my understanding, with regard to the Model Act. So I'm hopeful that we can leave that piece as promulgated or as is likely to be finalized in the Model Act in the coming month. Are there any comments on the waiting period piece? Representative Morris.
Thank you, Madam Chair. No, I went back and forth, but I'm not really, as we discussed too, I don't think people that buy pet insurance are the ones that usually already, are buying the best food for their dogs. They're making sure their pets are taken care of. So I don't think, I think it's a very niche market, and I think it's something we can monitor. And if in the future there's a change needed, we can look at it then. It'll be interesting to see how our experience goes, as well as within other states. I think that I don't think pet insurance is something that is widely bought and sold. So I'm certainly comfortable with it as is, as is for now.
Thanks, Representative Morris. So then the second issue that was raised, I'll just deal with the other issue, the effective date. I think it makes a ton of sense to put an effective date in place, which would allow pet insurers to file their forms and register, do the filings they need to do with our Bureau of Insurance and give the lead time that's needed to implement the regulations. So I would hope that the committee would adopt the effective date as Colleen queried about in her analysis. The last piece was the marketing of wellness programs that are not insurance during the sale of pet insurance. And I just wanted to share with the committee sort of my experience. And, I have, as I've told you, my pandemic puppy isn't in the room at the moment. It's my older dog who's here behind me. But, I recently purchased more health insurance or more pet insurance when I adopted a dog in 2020. And I did so online. I think as our experience online, if you could kind of imagine how that experience online can go, I think it would be appropriate for me to purchase the policy, have reviewed all of the materials related to all my choices with regard to the policy, the cost with regard to the policy, completed that transaction, and then have the website forward me to a dog food ad or forward me to, an ad for BarkBox or an ad for a wellness program. That would be perfectly acceptable under the language of the proposed statute. But what wouldn't be okay would be before I checked out, before I finished my my purchase of an insurance plan, for it to pop up and say, add this on, sort of more the way that when you're buying your like your airline tickets, you can't get to the checkout without checking whether you want trip insurance or not. I think wellness shouldn't be wrapped up in that transaction. And that's what the NAIC model tries to do, is to separate out the insurance transaction from the non-insurance marketing or additional add-ons, rather than trying to conflate the two, which I'm sure has some marketing benefits for the companies that are selling both of these products. But I think that they have real potential risks for consumers if the transaction is conflated in time or on the screen. in that way. So that's why I'm comfortable with the NAIC language as it stands. I also think this is an area where if the NIC were to update their language or edit their language, we could come back and edit ours as well in the future. So that's sort of my reflection as the sponsor of the bill on the testimony that I've heard with regards to the marketing of wellness programs. So I'm going to stop there and open it up to the committee discussion on that topic. Representative Melrano.
Thank you, Madam Chair. I would actually agree with you, and I think we can leave in that provision that you put in, and so I do agree with you. I also think the example that I believe it was Mr. Garrity that used this example, if you were working with a producer, for example, and the customer initiated question comes up, well, what about this wellness program? I think a response by the producer to that question is not marketing. And I think, I'm sorry, I didn't get the testimony person. I'm not sure it was Garrity or not, but. And so answering a customer's question about a wellness program versus marketing that wellness program while you're actually talking about the other product, I think that's perfectly clear in my mind. So I would also support leaving that whole provision in as well.
Thank you, Representative Morris.
Thank you, Madam Chair. And I think it was part my question and part Mr. Garrity's testimony, I think, on that. And I think, as Representative Melrano said, there's I think the way the language is written in your explanation certainly makes me feel like, we don't want to put anybody in a gotcha situation where because, as I said, it may not be they would necessarily know it as a wellness product, but they talked to their vet and their vet told them about it. And so they ask the insurance producer, or they are, or they talk to a friend that bought the product and their friend told them about it. And so they have questions about, well, does it cover my dog's regular visits or my dog's Bravecto or any of the other things? So I think the way you said it, I wonder if maybe someone from the Bureau could come in and just make sure that would be sort of how they would interpret it. Sure. Just so that we don't, they know what our intent is, essentially.
Yeah. I'm going to bring in Mr. Yardley to answer that question for you. Good morning, Mr. Yardley. Can you answer Representative Morris's question?
Yes, thank you. I'm Ben Yardley, a senior attorney at the Bureau of Insurance. I can't see myself, but can you? There I am.
Yep.
I think I think Representative Melrano has raised a valid point, and so I don't think that would be an issue for the Bureau if a consumer asks a question. I would hope that the producer, and I can tell you that over 80% of these transactions are done by call centers. So I would hope that the question about the wellness program wouldn't turn into marketing. But I think if it's raised by the consumer, then the question should be answered.
Okay, thank you. Just along the same line, as it relates to pet insurance, obviously right now it's not under any sort of regulatory umbrella, and this would bring it under a regulatory umbrella. Are there, and I support this legislation because this is about consumer protection, But has the Bureau as of right now been had any issues with pet insurance?
We've had
Heard any complaints?
I'm sorry for interrupting you.
No.
We've had 4 or 5 complaints, and there's a consent agreement with a insurer. Doesn't relate so much to on its surface to the content of policies, but they were using unlicensed producers. And so obviously there are concerns there. And that's why the training portion of this model is so important.
Yep.
Representative Morris, are you all set?
Yes, I am. Yep. Thank you.
And Mr. Yardley, on a slightly different topic, so my understanding is that there's sort of only one area of outstanding issues related to the NAIC model, and that area is related to limited lines producers. Is that your understanding?
Yes, it is.
Okay. And what I have suggested, I actually had an inquiry from an interested party who was hoping that health insurance producers could sell pet insurance so that your whole family could be protected. And I have no issue with that. But I suggested that might be something the committee could revisit next year after the NAIC had sorted out their issues with regard to that. Does that sound like the right approach?
I would say so. I wouldn't tinker with it at this point.
Okay, great. Thank you for your input. Are there any additional questions for Mr. Yardley? All right, I'm not seeing any, so I'm going to move you back into the attendee space. Thank you. Representative Tepler.
Thank you, Madam Chair. Is it an appropriate time for a motion?
Yes.
Okay, I would like to move ought to pass as amended with the effective date. I believe that is part of an amendment. And that's my motion.
Great. Is there a second for Representative Tepler's motion, seconded by Representative Evans? Is there any further discussion on the motion? All right, seeing none, I'll ask the clerk to call the roll.
Thank you. Senator Sanborn.
Yes.
Senator Sanborn, yes. Senator Brenner. Senator Stewart.
Yes.
Senator Stewart, yes. Representative Tepler.
Yes.
Representative Tepler, yes. Representative Alford.
Yes.
Representative Alford, yes. Representative Bleier.
Yes.
Representative Bleier, yes. Representative Brooks. Representative Connor. Representative Evans.
Yes.
Representative Evans, yes. Representative Matheson. Representative Matheson.
Yes.
Representative Matheson, yes. Representative Malorino.
Yes.
Representative Malorino, yes. Representative Morse.
Yes.
Representative Morse, yes. Representative Quinn.
Yes.
Representative Quinn, yes. 10 members of the committee having voted in the affirmative and 0 in the negative.
Thank you, Edna. So we will be adjourning for a lunch break until 1 p.m. And we will see folks back here at that time. Thanks, everyone.
Thank you, Colleen.
No problem. I'm getting it set up now. And the one thing you could do is you can change the view on your computer. So that if you wanted to, so that my background shows up in the whole screen. But I think you have to do that since you're the
Oh,
host.
how do I do that?
Is there a way to sort of change it to speaker view?
Mm. Okay.
Up in
Would
the
that-
corner where it talks about view.
Yes, you hold right on here.
I think if you change it to speaker view,
Speaker view, yes.
then I think my window will show up. Does that show up?
I've got it from here, but I don't know.
Is it showing up? You can see mine.
I
my
can see
screen.
yours on your screen.
Yep, just my screen.
Yes.
And it should be working for everybody else then. So, okay.
And then I just go
good.
back and take that off.
No, just leave it for now and then
Yeah.
we'll leave it up.
We do it when we come back on. Okay.
I'll pull it back off. Yep. And then when we
Okay.
come back on, you can change the view. Yep.
Okay, thank you.
All right. I'll see you in 1.
Okay. Representative Matheson, I'll change your name.
It is 1:04, but we do not have a critical mass of the committee returned yet. I only see 5 members at the moment. 1, 2, 3, 4, 5. I think Representative Quint is there, so that makes 6, but that's still not enough for us to work quite yet. I thought you were there. I saw you had put up a screen over your camera, so that's fine.
I'm over at someone else's house, so I'm kind of keeping their house private.
I figured that was fine. I'm glad you're able to find broadbands. Hopefully we'll be able to get it to every main house soon. Okay.
Hi, Colleen. This is Heidi. I'm using your link. If you could rename me, and I'm not sure that I'll get the video working in my bedroom as I am. So
I'll get that for you.
sure.
Heidi, it's no problem if you can't get your video working. We just won't be able to have you vote on screen. You'll have to send your votes in by email to the speaker's office.
Yeah, that would be great. I want to participate for sure, but
Yep.
Just
that's
changing
fine.
rooms and everything.
That's fine.
I can be blue though, or green, or I'll stay black. Either way, I'll show them either one.
I think if you're blue, then people who are watching on YouTube can see that you're here. So that might be good.
Yeah, that's what I was thinking. I realized that after the first couple of meetings that if I'm blinking off and on, that people can't see me. So I'll do
Yeah.
the video and I'm on.
Great.
Sorry about that.
No problem. Okay. We're still waiting for enough folks to join us so that we can get started, although we're getting close. And I did receive a message from Representative Tepler that she'll be joining us shortly. And I think Representative Arford is with her as well, or on the same time schedule. We're just having one of those days where everything's on old school legislative time instead of Zoom legislative time.
No, I appreciate everybody's working together, like the teamwork.
There we go. Okay, so if the folks who are at their desks could turn on their camera, then I think we've got a quorum and can get started with our afternoon work sessions. Perfect. Okay, so the next bill that we're going to take up this afternoon, and just to give people a heads up as to how I plan to proceed. So I'm going to proceed with LD 1956 and LD 1973 first. I think those will be much more quick. And then the committee will discuss LD 1196. I anticipate we may not take our final vote on that bill today. So we're going to hold it until the end of the work session and work on it then. Okay. So with regard to LD 1956, this is an act to update the consumer credit laws related to legal funding practices. And it is our first work session on it. So I will have Colleen present her bill analysis.
Great, here we go. I'm going to start with LD 1956. Senator Sanborn gave you the title, but the bill as drafted makes some changes to our current law that governs legal funding practices in the Consumer Credit Code. The bill provides that the law applies only to consumer lawsuits, including class action lawsuits, and it would add language specifically stating that the law does not apply to a commercial entity in support of commercial litigation. It makes some changes to the definitions of legal funding and litigation funding provider in the current law. And it, with regard to the disclosures, there are some already in current law, but it adds to the disclosures that must be made to consumers before entering into a legal funding contract, and also adds a specific language related to prohibited conduct of a litigation funding provider. The bill provides that a legal funding contract must be disclosed to all parties to litigation by the consumer or the consumer's attorney, including to the consumer's insurer. And it also contains a provision related to enforcement that would say that any violation of legal funding practices provisions would make the legal funding contract unenforceable. I did add to the electronic LD file a copy of the current law, which is in the main Consumer Credit Code, Article 12. But as I mentioned, under the current law, litigation funding providers are currently regulated by the Bureau of Consumer Credit Protection. They are required to register before engaging in the business of legal funding in Maine. A legal funding contract is defined in the law as not being a loan, as it's a non-recourse transaction. So what that means in this context of a legal funding contract, a consumer accepts an advance of money to provide funding for litigation in exchange for repaying that advance plus any fees that might be required under the contract, only if the consumer prevails in the lawsuit. So the repayment by the consumer only happens if they prevail in their lawsuit and receive monetary proceeds as a result of that. The current law also has some requirements for the legal funding contracts themselves and requires specific written disclosures to consumers. In the testimony from the Bureau of Consumer Credit Protection, they noted that there are currently 4 litigation funding providers on the roster of those currently registered with the Bureau of Consumer Credit Protection or licensed with them. Sort of the focus of much of the testimony that you received at the public hearing on this bill was on the provision that requires disclosure of any legal funding contract to all parties in litigation prior to a discovery request. You did have testimony about 2 states that have enacted a similar provision, Wisconsin and West Virginia, and similar proposals are pending in several other states. With regard to this provision, the proponents suggested that since defendants in a lawsuit are currently required to disclose the existence of any insurance coverage that someone has, the same rationale for requiring disclosure of that coverage should apply to the existence of a legal funding contract, and that the disclosure should be mandatory. I apologize, there's a typo there. The testimony from the opponents you received suggested that the question of disclosure should be addressed as part of the discovery process in a lawsuit, and that consumers may be disadvantaged in litigation if automatic disclosure would be required. Under existing court rules, there are provisions for requiring disclosure by order of the court as part of that discovery process, and the court's rules of civil procedure and other provisions govern that process now. So the question, I guess, for the committee is whether the change in the bill is necessary. What it would do is require automatic disclosure sort of outside that existing discovery process that may require disclosure of these legal funding contracts as part of a lawsuit. There was another provision that generated some testimony in the bill as well that I wanted to note for you. There is a provision that would prohibit a litigation funding provider from assigning a legal funding contract in whole or in part, including securitization of those contracts. And you did have some written testimony and oral testimony submitted by the American Legal Funding Association opposing this provision, raising concerns about its effect on the availability of capital for litigation funding providers, and noted that because these contracts are non-recourse transactions, there are some differences between litigation funding providers and other more traditional, traditional lenders of funds. So access to capital is very important. And then lastly, they mentioned the enforcement provision. The language does state that the legal funding contract would be unenforceable when any provision is violated, but there's no mention about whether or not there might have been any monetary advance made by the litigation funding provider as part of that, and if this provision or the intent of this provision would require any refund of any monetary advance that might have been paid out before a determination or before a violation has occurred that would make the legal funding contract unenforceable. We don't have the fiscal information yet from the Bureau of Consumer Credit Protection and the Office of Fiscal and Program Review. So that should be coming soon if the committee moves forward with the legislation. I think I will stop there. I don't recall that I have seen any additional information coming into the committee since the work session on this bill, but I know you have folks here from who testified at the public hearing, and the sponsor of the bill is here as well, Representative Morris. So I'll stop there and I'm happy to answer any questions.
Representative Morris, go ahead.
Yes, thank you, Madam Chair. So I'm looking on your analysis. Obviously, I put the bill in. I'm not an attorney, so I've never sued anybody. But the question that I have deals with, it talks about disclosures during discovery versus this particular situation. So during discovery, this sort of disclosure could potentially be made. Is that what I'm understanding?
Yes.
But what I guess, what are the circumstances that this would end up being made versus making it mandatory? I mean, what are the circumstances under which someone would be required to put forward this sort of agreement, that this agreement is in place?
Well, I think it's hard to say specifically what those circumstances would be, because I think the decisions about discovery would be made on a case-by-case basis, you know, as a result of whatever the lawsuit is. So the determination, as I understand, you know, of whether or not disclosure of these agreements would be ordered as part of discovery would be sort of part of the lawsuit and determined by a judge who is making those determinations, with giving the opportunity for both sides, both parties to the lawsuit, to make arguments one way or another. If someone moved to have this disclosed, then the consumer's attorney, or, you know, could then make arguments as why it would not be appropriate. And then the judge would make the determination according to, you know, what the rules of civil procedure are. And so what the legislation would do, as I see it, is it would make sort of that disclosure mandatory up front. And it sort of, obviously it would have some advantages to parties to the litigation for having that done on a mandatory basis, as opposed to having it determined as part of the discovery process for the lawsuit. And the discovery process would go beyond just this particular information. It would cover, you know, the exchange of information between the parties that goes beyond just the existence of a legal funding contract. It would be all the other circumstances or information that would be required to be, or would be sought by each party as part of the lawsuit.
Representative Evans.
Thank you, Madam Chair. I'm just wondering, if you make this mandatory, from my perspective, you are disrupting the rules of civil procedure, as well as the discovery process in general. I'm not sure that's the road we want to take.
Representative Evans, that sounds like a very good statement with which I agree, but is it a question for Colleen?
It's a question for anyone. Colleen, anybody that may have an answer to that.
I'm not sure Colleen can answer that because that's a policy question, but I'll take a stab at it.
Okay.
Which is to say, I as I've sort of tipped my hand in my prompting to you, I completely agree, and notably so do the federal courts. So the federal courts looked at this issue and looked at the question of whether they should change their provisions with regard to discovery of litigation funding agreements, and decided to take no action after looking at it for a couple of years, is my understanding. And I think the courts are just well suited to consider whether such an agreement is relevant in a particular case, given the facts in a particular case, which might include a counterclaim or some other type of action that could complicate the roles of the parties and put the plaintiff's assets in question. But because this committee doesn't deal with this sort of thing very often, and I am an attorney, although I've never used these litigation funding agreements, I guess I would just say that I think that the plaintiff absolutely doesn't stand in the same shoes as the defendant insurance company. This is not two sides of the same coin the way it was represented to us. And here's the reason why. The plaintiff, these cases are generally personal injury cases. So the plaintiff is someone who alleges that they have been injured by the defendant and that they are owed money by the defendant. And usually that money judgment would be satisfied by an insurance policy. So it is absolutely relevant to the case, to the actual recovery in the case, whether there is an insurance policy and what the amounts and parameters of it are. It's literally part of the case. And that's why insurance is automatically disclosed in those types of cases. But the plaintiff's financial situation, their own ability to pay their own mortgage or their own medical bills or their own car insurance payment, or keep their lights on or their kids fed, that's not relevant to the defendant or to the insurance company, except to let them know how much to handicap the settlement and how quickly that person might be forced to settle. And frankly, to make them feel uncomfortable about their own financial circumstances or even embarrassed about them. And that shouldn't be part of litigation. And it's certainly not just the flip with regard to an insurance contract. So with all due respect to the folks who have suggested to us that it's two sides of the same coin, I absolutely disagree. So just wanted to put that out there. Representative Morris, go ahead.
Thank you, Madam Chair. And I'm certainly not going to argue legalese with you because I am, as I've said, I am not an attorney, and I couldn't, I couldn't sit here and it would not be a fair fight as the committee would say. And I say that favorably toward you. The reason I support the bill and I support that provision, though, is I think it wasn't just the insurance that testified on this. It was also the Retail Association as well as Maine Motor Transport. And I would just, right in Brian Park's testimony, it says, what we see increasingly is that plaintiffs are unwilling to take a reasonable settlement offer because the funding arrangement doesn't allow them to meet their obligation to the financing company. We don't think that personal injury trials ought to be profit-making vehicles because suddenly a truck accident looks like an investment opportunity. And I think what I'm trying, the reason why this disclosure, in my view, is important. I understand what you're saying on the insurance side. They need to know what the potential they could get. However, the other side of that is, in that instance that Brian Park is laying out in his testimony, it is not necessarily the plaintiff that is making the final decision, in as much as it is the hedge fund that is backing them because they're worried they have to pay off some of these usurious rates, where we heard one testify it could be upwards of 66% when pressed on the question piece. And I think that if there is an agreement in place and the defendants don't know about it, and they come at what should be a reasonable offer in that lawsuit for a settlement, and they turn it down because there's somebody else backing them. So that's who's making that financial decision. It's not, the issue is that it's not always the plaintiff necessarily making that decision. And again, this is really just about making sure that there's transparency in this process. I think that's what, because I think it's again, I'm concerned about, the Retail Association of Maine and what their reasons were for testifying in support of the bill, as well as the Maine Motor Transport. These are big industries in Maine that I don't think, we need, that I think we should certainly take into consideration what their issues are with, if they're being sued, if the plaintiff is also being backed by an outside funding entity that's not in Maine, whose interest is more financial than on the well-being of the defendant. I think that should be known to the defense up front. So that's, and again, not being an attorney, not knowing everything in terms of that, but that's just my initial look at it from my view of the world. So,
Representative Tepler.
Thank you very much, Madam Chair. And just in response to Representative Morris's concerns, it's my understanding that the representatives who we heard from who represent the lending industry in Maine, the legal lending industry in Maine, have testified that we don't have a problem with hedge funds investing in legal lending in Maine currently, that it's all smaller companies at this point. And it's also my understanding that this is still fairly unusual in Maine, that because of contingency fee agreements for most plaintiffs' attorneys, legal lending, it only comes into play when a plaintiff is desperate and about to lose their home or in a very, very difficult situation. And otherwise, it's quite rare. My husband reported to me that of the hundreds of cases that he has done over the last number of years, there have only been 2 that involved legal lending agreements.
Thanks, Representative Tepler. Representative Brooks.
Thank you, Chair Sanborn. I was wondering if we could hear from Superintendent Lund for more information regarding consumer credit protection.
Sure, I can bring Mr. Lund in. Good afternoon, Mr. Lund. I'm wondering if you could speak to, and I think I'm going to try and summarize what I think Representative Brooks's question might be. Can you speak to whether you think that there is a problem here for Maine consumers that the committee should take action on?
I can confirm that the volume of litigation funding activity in Maine is very low, both in terms of the numbers of companies that are licensed to advance funds under the law, and also the dollar amount, the total dollar amount in Maine is really the equivalent of 1 or 2 mortgage loans for the entire state per year.
And have you received complaints with regard to litigation funding for your office?
We have not received complaints. We receive occasional calls from attorneys whose clients are interested in exploring those arrangements. So we respond to the questions, explain the protections that are in the current law, and that those are the only communications we've had.
Thanks. Okay. Representative Brooks, did you have any additional questions for?
That was my major question. Thank you for summarizing, Chair Sanborn.
Sure. Okay. Are there any additional questions for Ms. Lund? All right. Thank you for joining us. I'm going to move you back into the attendee space. Representative Tepler.
Thank you, Madam Chair. And with all due respect, Representative Morris, I think this is an issue that may be a problem in some larger states with more and higher rates of expensive litigation. But I don't believe that we have a problem we need to solve here now. So I would move ought not to pass.
Is there a second for the motion? Seconded by Representative Evans. Is there further discussion on the motion? Representative Morris.
Thank you, Madam Chair, and I'm not going to belabor this point because I know we've, but I will say I will be opposing this motion. I do think that just because we think it's not a problem, the issue is we don't know, because there haven't been complaints into the doesn't mean it's not going on. And this is not prohibiting the practice in any way. It's just trying to shed light and bring more transparency, because the potential for our small businesses to be caught up when they try to make a reasonable offer and be in one of these cases and be told no, and it's because there's a large hedge fund that's not headquartered even in this country that's pushing the litigation. I think that that's a real problem, and I think that the Maine people and Maine's businesses deserve to know who might be funding some of these projects, who might be funding some of these lawsuits. It may not be a huge problem. You may be right, Representative Tepler, but I think all this is trying to do is bring more transparency into the process. And I think if some of them are charging, again, as one said in their testimony in an answer to a question, up to 66%, the average being 66% interest rates to the consumer, I think that should be known as well. So,
Representative Morris, I'm going to take a chair's privilege here, Representative Tepler, and not call on you just yet. But I wanted to. I'm confused a little bit about the notion of these foreign hedge funds providing the financing. I know that that was referenced in a Wall Street Journal article, but I don't believe that could happen here because you have to be registered with the Bureau of Consumer Credit Protection in Maine in order to give out these kinds of loans. It is possible that those, and I think we heard testimony that those financial entities do get some of their funding, their capital sources from, other investors through securitization. So I suppose you could shorthand that and say hedge funds are doing this, but actually it's a regulated, registered entity, and we know exactly how much money. Will Lund just told us it was less than a couple of residential mortgages per year was coming into the state, which sounds to me very different than the picture you're painting, which I think is based on the Wall Street Journal article and maybe based on states that do not have the type of regulatory regime that we have had in Maine since 1974. We were one of the first states, maybe the first state, to have such licensure and registration provisions. So we may not see eye to eye, and it is perhaps not worth further belaboring the point, but I did want to just put things in context, that we're not talking about, sovereign wealth funds in the Middle East directly plumbing money into litigation against small businesses in Maine. That's just not the reality of where we are today. So I just say that and then call on Representative Tepler.
Thank you, Madam Chair. And I agree with the statement you just made. And I feel it's really important to reiterate what you said earlier, that when it comes to transparency, we're talking about people in two very different positions here. We're talking about an injured plaintiff who seeks remuneration for an injury or bad circumstance that they have suffered versus an insurance company, which is providing coverage for a small business or a trucking company. The businesses and trucking companies themselves are not even the objects of the discussion. The insurers of those entities are. So to me, the transparency issue is really not, doesn't make a whole lot of sense. And it puts people who are in desperate circumstances in an equal position to people who have insurance policies to cover them for losses.
All right, I'm going to look to the committee for a motion because I don't necessarily think that we're changing minds, but is there a motion? Oh, there already is a motion.
We already had one.
Oh, right. Yeah. So there is a motion. I'm happy to continue conversation if we think we're changing each other's minds. But I also know that not every vote in the Maine legislature is unanimous. So Representative Morris, are you ready to proceed with the vote?
I am. I'll just one more. I would just say in terms of the With I understand that it's the insurance company that's going to be paying out in that case. However, it's going to impact the insurance rates of that company, which does impact consumers in the form of higher prices down the road with some of these. And again, I go back to, it may not be a huge problem, but I think there's nothing wrong with putting this in statute and asking for more sunlight onto the topic. So I will be voting against the motion. Again, we don't need to sit here and debate this all afternoon. I don't think anyone's changing anybody's mind. So.
Right. Okay. With that, the clerk will call the roll.
Thank you. Senator Sanborn,
Yes.
Senator Sanborn, yes. Senator Brenner, Senator Stewart, Representative Tepler,
Yes.
Representative Tepler, yes. Representative Alford,
Yes.
Representative Alford, yes. Representative Bleier,
Yes.
Representative Bleier, yes. Representative Connor, Representative Evans,
Yes.
Representative Evans, yes. Representative Matheson,
Yes.
Representative Matheson, yes. Representative Malorano,
Yes.
Representative Malorano, yes. Representative Morris,
No.
Representative Morris, no. Representative Quinn,
Sorry about that. Yes.
Representative Quinn, yes. 8 members of the committee having
Did you get
voted.
me?
We did.
Yes, I did. 8 members of the committee having voted in the affirmative and 1 in the negative.
Thank you, Ms. Kayford. All right.
Can I just clarify, Representative Morris, what your report would have just be straight ought to pass or any
Yep.
changes?
Yep.
Okay.
Yep.
Thank you.
Okay. And we will just remind folks that any absent members can cast their votes through their presiding officer. And so if you're not on camera, you can do that. And we'll also make sure we send out an email to the folks who are not attending the meeting, letting them know they can cast their votes on this bill. The next bill we're going to pick up is LD 1973, an act to support frontline healthcare workers by waiving professional licensing fees. Colleen, will turn to you for your bill analysis.
So this bill is LD 1973. As drafted, it proposes to waive professional licensing fees for emergency medical services persons, registered nurses, licensed practical nurses, respiratory care practitioners, midwives, and persons associated with those practices for the period from March 1, 2020 to December 31, 2022. It would require that any professional licensing fees paid for that period be refunded to that person. You also had an amendment that was submitted by the sponsor prior to the public hearing that proposed to add physician assistants to the providers that would qualify for a waiver of their professional licensing fees. As I mentioned, the bill would require licensing fees for these specified types of providers to be refunded from the period of March 1, 2020 to December 31, 2022. It does not indicate the source of that funding, and you have received some testimony from the boards that oversee the licensing of these practitioners, that if the boards were required to refund fees, the loss of their dedicated revenue would impact their operations and require significant staff time and resources also to process these refunds. So you might consider the impact on the dedicated revenue and consider maybe some other potential sources of revenue. And I think the sponsor provided some suggestions at the public hearing about that. The other thing to keep in mind is that you might recall that during the in March of 20, the bill would apply retroactively back to March 1 of 2020. But at the beginning of the pandemic, the governor did issue an executive order that extended the expiration dates of licenses for those practitioners licensed by the Board of Licensure in Medicine, the Board of Osteopathic Licensure, and the State Board of Nursing, particularly until 30 days after the end of the declared emergency. The declaration by the governor of a public health emergency did expire at the end of June in 2021. So any licensee described in that executive order would not have been required to pay a license fee between March 2020 and July 31 of 2020, June 30, 2021, excuse me, July 31, 30 days after the end of the emergency. That executive order also did direct the issuance of free emergency licenses to certain qualifying physicians, physician assistants, and nurses, those who were recently retired or out of state during that time, to sort of expand the state's capacity of healthcare workers to respond to the pandemic. I did also want to make you aware that you might recall legislation was considered last session in another committee of the legislature, the IDEA committee, that proposed to waive all professional and occupational license fees for calendar year 2020. It would have applied, beyond the practitioners that are outlined in LD 1973 to include all those professions and occupations licensed pursuant to Title 32 of the Maine revised statutes. That bill was considered, reported out as a divided report of that committee. The majority ought not to pass report was ultimately accepted by the House and the Senate, but the minority report of the committee, which would have proposed a waiver of these fees, did specify that the source of the funds to be used to reimburse those people would be federal funds that might be available from the Federal American Rescue Plan Act that would be eligible for that purpose. So that's just a sort of a little bit of legislative history for you. You did ask for some additional information from the Department of Professional and Financial Regulation, the Office of Professional and Occupational Licensing. Commissioner Head did follow up, and that information was emailed to the committee and uploaded to the electronic LD file. She provided some information about the current fee schedule for licensing boards and the dedicated revenue used to support their operations. She also, in response to one of the committee's questions about how other states address sort of the funding structure for occupational licensing, and the memo notes that she found 21 other states use a similar dedicated revenue funding structure like Maine does. The last thing I guess I would mention, two things, I guess. One is here on the analysis is there was a suggestion in testimony that if the committee is interested in pursuing some sort of monetary payment to healthcare providers, that you might consider enactment of a refundable tax credit. That's something that's being considered in some other states. Hawaii was, as an example, was provided in testimony from the Maine Medical Association as an option for the committee. And then committee members had asked about licensing fees and how they are paid currently, and whether employers of these practitioners, as a matter of course, provide reimbursement to them for their licensing fees. I think you had some testimony at the public hearing about some of the practices of Maine Health and other entities, and you would ask for some follow-up information from Ms. Harvey McPherson about nurses. She reported back to me that she was unable to find sort of meaningful answers to that question in terms of getting feedback from the association she represented at the public hearing about how they handle it whether or not it's handled like that in a uniform manner or not. And I will stop there. I'm not sure if she was able to, she wasn't sure that she would be able to attend the work session, but I do know that others are here representing some of the licensing boards you received testimony on the bill from, if you have any further follow-up questions.
Are there questions for Colleen? All right. I'm going to kick us off here by just saying that I understand the intention of the bill as a gesture to our healthcare providers over the last 2 years, but I think there are some serious unintended consequences. And I think as a gesture, it has a lot of administrative and bureaucratic sort of hurdles around it as well. With that, I'm going to suggest an ought not to pass motion. Seconded by Representative Evans. Is there further discussion on the bill? Representative Melorano.
Thank you, Madam Chair. I don't work in healthcare myself. I did work through the pandemic in a customer-facing job for a call center. About a year and a half into working through the pandemic, in both jobs, I was suffering from some serious burnout, which I think a lot of people have really faced, and anyone who's worked through the pandemic. And I can only imagine what it must be like for healthcare workers if other workers are feeling that burnout as well. And I do think this is a great time to mention that in the USA, including Maine, we are near the bottom, or if not at the bottom, in terms of worker protections and benefits. So we don't get 4 and 5 and 6 weeks vacation time like all other developed nations afford to their workers. So no wonder everybody's burnt out. I think what we need to focus on as state lawmakers, and certainly keeping the pressure on the federal lawmakers as well, is that we need to make things better for all workers in this country, in this state. I think that there's very little opportunity for work-life balance for most American workers. And I think that's a real tragedy. And I think this is a great time to mention that. I think this is obviously, not where we're going to go in terms of serving these workers. I think we can best serve them by advocating for them in terms of more paid time off, more actual sick time, more protections and rights in the workplace in general. So I am voting yes on the ought not to pass motion for this particular effort. But I think I just thank the sponsor so much for honoring these workers, and thanks for letting me speak.
Thanks, Representative Melorano. Are there any other comments on the motion? All right, not seeing any, I'll ask the clerk to call the roll.
Thank you. Senator Sanborn.
Yes.
Senator Sanborn, yes. Senator Brenner. Senator Stewart. Representative Tepler. Representative Alford.
Yes.
Representative Alford, yes. Representative Bleier.
Yes.
Representative Bleier, yes. Representative Connor. Representative Evans. Representative Evans.
Yes.
Representative Evans, yes. Representative Matheson.
Yes.
Representative Matheson, yes. Representative Melorano.
Yes.
Representative Melorano, yes. Representative Morris.
Yes.
Representative Morris, yes. Representative Quinn.
Yes.
Representative Quinn, yes. 8 members of the committee having voted in the affirmative, 0 in the negative.
Thank you, Edna. Okay. Next committee, we're going to turn our attention to LD 1196. And this is an act regarding, originally an act regarding targets for health plan investments in primary care and behavioral health. We have had several work sessions on this bill because we first had a meeting or a stakeholders group that reported back to the committee And then we proposed a committee amendment, which we held a sort of pseudo public hearing on at our last work session. And I think it makes sense probably for, I don't know if it makes sense to screen share the draft amendment for a moment, Colleen, and I think I'll kind of walk through what I think the different, there's 3 or 4 different topics in there, and I want to kind of outline those for the committee so that we can then take them each in turn. And as I said, I think earlier on, Mike, I don't anticipate that the committee will vote on this proposal today. But we're going to try and pull out the information that we need on the different sections of the bill and the different issues that are in each part. Yep. So I guess I would summarize part A as being about MHDO data gathering and reporting. Colleen, does that seem right?
Yes, this would sort of add in statute a specific requirement for the collection of MHDO data related to behavioral healthcare spending and then reporting back to the legislature by the Maine Quality Forum. And it's modeled after existing provisions in the statute that require the same type of report for primary care spending.
Great. Okay, I just want to sort of outline the bill or the amendment as it stands. So that's A.
Yeah.
What's section B about?
Section B are the changes to the insurance code with regard to credentialing and carve-outs for payments for behavioral healthcare services. So it makes 2 changes related to credentialing and prohibits carve-outs with regard to payments, and sort of the focus is restricting carriers from having separate credentialing processes or more restrictive credentialing processes for behavioral health care than they have for other types of services, and similarly with regard to submitting claims for payments.
All right, part C.
And then part C makes changes with regard to the Maine Care program and how they process and make decisions about claims for behavioral health services, making similar changes to their statutes that were made with regard to insurance in terms of not requiring separate credentialing and billing processes for behavioral health services, or requiring additional authorization or certification of providers of behavioral health care services for those primary care settings that might want to integrate primary care and behavioral health settings. And then it also would ask the department or direct the department to complete its review of reimbursement rates for behavioral health care services. That is part of an ongoing process, but it would direct the department to complete that process for these services by the end of the calendar year.
Great. Okay. Thank you for running through that outline for us. So I want to have the committee kind of take each part separately and discuss where we are and any additional information that we need with regard to each part of the bill separately. So first, we're going to turn to part A, which is the MHDO data gathering and reporting provisions. And I think the committee has received some feedback on these provisions, particularly from the insurers with regards to whether the definition is overbroad. And then with regard also from Maine Care to whether the data that would be collected from Maine Care was apples to oranges with the data that would be collected from private insurance. So I think, at least to help me with those questions about the definitions, I think it would be helpful to pull in Mallory Shaughnessy and Karen Lee Harrington. And then I was actually hoping to pull in someone from Main Care, but I
I
don't.
think Olivia Alford is here from Main
Okay.
Care. It looks
Perfect.
like
All right.
in our attendee space. I don't see Michelle Probert or
I
Molly
don't
here
see
right now.
Michelle or Molly. Okay, great. I'm going to bring those 3 people over and we're just going to talk about the first part. And it's possible some of those same people might be helpful to us when we talk about the third part. But I want to try and just focus on that disclosure piece to start with. All right, so good afternoon and welcome. And I think probably for the public's benefit, it might be helpful if each of you could just introduce yourself and let us know who you represent. Go ahead.
Hi. Who's going first?
Go ahead, Ms. Shaughnessy. Yes, thank you.
Okay. Hi, Mallory Shaughnessy. I'm the Executive Director of the Alliance for Addiction and Mental Health Services, which is the state's statewide association of treatment providers of those services for the safety net.
Okay, Ms. Harrington.
Good afternoon, Karen Lee Harrington with the Maine Health Data Organization.
Thanks. And Ms. Alford.
Hello, I'm Olivia Alford. I'm the Director of Delivery System Reform for the Office of Maine Care Services.
Great. So my question is about this definition of behavioral health. Ms. Shaughnessy, I suspect it came from your organization. Can you give us some insight on whether it has an origin somewhere or whether it was written by this group or if it's like based on a national definition or something like that?
My understanding in our discussions was that it came from the SAMHSA federal definition.
Okay. There was a question raised by the insurers as to what it meant when it said something like inappropriate use of healthcare. And I don't have the language directly in front of me. Do you know what that means?
I actually don't have that right in front of me either. I've been sitting in I'm on my phone too. I've been sitting in a work session on another committee for a while and just realized that we were up over here.
Okay.
So I don't have that right in front of me.
I can come back to you on that question. But that was a question that I shared that the insurers asked about and that I wasn't sure the answer to either. But it looks like Ms. Harrington also might have some insight. So go ahead, Ms. Harrington.
I just wanted to throw out there an idea. When I think about the primary care work that we're doing, the definition in the statute around primary care provides a framework. But then to operationalize that, to go into the data and pull the data to come up with estimates, we have to get a lot more detailed. We have to list out what taxonomy codes we're going to include. We have to look at all the services that would be part of it. And we convened a stakeholder group to do this work in the primary care world. And we would do the same if this were to pass. And so my thought is to have a definition that provides a framework that's clear, that, is not, and I'm not sure that the definition that's currently is exactly the SAMHSA definition. So we have proposed something that I think is more aligned with what the payers were suggesting, just as a framework, and then all the details will follow as we work to operationalize the framework.
Okay. Have you suggested that to us somewhere that I'm missing?
I emailed it this morning, but I know you were bombarded with emails because it came in this morning. So, but I could pull up the email. I could pull it up for you if you're interested, but the language would say behavioral health care means services to address mental health and substance use conditions provided by licensed practitioners. So it was similar to what the carriers had originally suggested. And then there was an unallocated section of Part A, you might remember, which directs MQF to sort of develop best practices for reporting. And I think that's where the stakeholder group comes in.
Okay. All right. Is there further discussion or questions from the committee? Representative Evans.
Thank you, Madam Chair. Ms. Harrington, you may not be able to answer this. Generally speaking, what types of services does Maine Care provide? Not knowing definitively each one, but in general, what types of services are you providing?
The good thing, Representative Evans, is you have an expert here from Maine Care with Olivia. So I'll punt that to her.
Sure. Yeah, thanks, Karen. So for behavioral health services within Maine Care, we cover a very broad range of them, which is going to be different than what you're going to see in the commercial markets. So we cover everything from crisis intervention, who you call and who responds to you in the community when you are in crisis, to counseling, outpatient therapies, assertive community treatment, high acuity services, case management, peer supports, all sorts of things that cover the full range of behavioral health needs. One thing I'll call out just with the definition that Karen Lee proposed is even the word licensed professionals. Within Maine Care, we actually, as I mentioned, cover peer support professionals, which technically are not licensed. So there are definitely nuances to when the language is applied to the Maine Care program where it will look differently than what traditionally you might think of as psychiatrists and social workers.
Thank you.
Yeah. And my understanding, Ms. Alford, just to follow up on that, is that Ms. Probert's comments to us in her letter suggested there might be some apples to oranges. I'm wondering if you think that the proposal that Ms. Harrington has forwarded to us this morning helps to alleviate some of those concerns because it would allow for a stakeholder process as the data collection tool is developed.
Yes, and we talked to Karen Lee through the primary care process that she was talking about still to try to nail down what is the best way to report, looking across the country for who's doing this similarly and how they include their Medicaid programs in that, and just allowing that that time to think about it so that when we are presenting it, it is clear when there are apple to oranges comparisons. And for Maine Care, part of it is that when you're thinking of behavioral health as a percent of total spend, our total spend is a different denominator than everyone else's. So we just want that to be clear, and we want to draw out where there are differences and just make sure that that's transparent and accurate.
Okay, great. Ms. Shaughnessy, I don't know if you're still with us or if you're trying to monitor the other hearing. My understanding is there is an HHS hearing on this very same topic going on right now. So
yep.
I'm wondering about your reaction to the more simplified language that Ms. Harrington has proposed. Behavioral health care means services to address mental health and substance use conditions provided by licensed practitioners. And then all the meat on the bones, all the particular codes and diagnoses codes and treatment codes would be worked out in a stakeholder group for the reporting purposes. Does that make sense to you? Or
well, and I think what Olivia just said is really important, is that there's a whole lot of other folks who are not those types of credentialed providers that are doing behavioral health care. And I just finally found the most recent version of it. And I'm looking at the definition of behavioral health in that last version that came out from the committee as and it's not the definition that I remember as having earlier.
Okay. All right. So what I'm going to suggest for how to proceed on this, because I am aware of the sort of competing HHS hearing going on right now. What I'm going to ask is that Ms. Harrington, Ms. Shaughnessy, and Ms. Alford kind of talk about that one line definition and see if you guys can suggest back to the committee something that is, appropriately broad and not overly narrow in all of the right sort of ways. Because I think you three are probably the ones to kind of hammer that piece of this out, including the unallocated language that would allow for the further hammering it out of it later, but just to make sure the framework is clear as we start out. Does that sound like something you folks would be able to work on in the next few days?
I think so, yeah.
Great. Okay, so are there any additional committee, is there any additional committee discussion with regard to Part A of our bill? Representative Brooks.
Again, I apologize for not being on camera. But yeah, with the definition part, and the coming out of the emerging with the pandemic, I would encourage keeping in mind that a lot of things are interrelated, and I think that people appreciate that, and that's all I'll add.
Okay, thanks. All right, so I think Ms. Harrington, I almost gave you a representative title. Ms. Harrington, go ahead.
I just wanted to throw out there are some data collection issues that I think we've learned from our experience with the primary care work, that if it's not in statute or in a rule, then the payers are less likely to voluntarily submit the data because they've got so many other things going on. It's not a criticism, it's just, it is what it is. And so there are two additional things that we are suggesting be included, which is the collection of non-claims-based behavioral health care payments. And then the second piece is, as a result of federal legislation, 42 CFR Part 2, payers redact substance use disorder data from their submissions to MHDO, and they redact more than they need to. It only impacts Part 2 providers, but nobody can figure out a Part 2 provider from a not Part 2 provider, so they take out everything. And we're suggesting if substance use disorder is going to be part of the definition of behavioral health care, if we don't get that data, there'll be a significant understatement in the report. So we've provided some language. It's rough, but we've just provided a framework for some discussion and hopefully agreement that that's important to include.
I see that now in the, I was thinking that add the following language was the unallocated language, but you're right, that's additional statutory language that you've proposed that's in Colleen's email that she forwarded to us this morning. I see it there. And so what you're suggesting is that if the payers can't disclose the individual claims level data because it's not de-identified, when it's disclosed under federal law, they could at least provide, and you would need the statutory authority for them to be required to provide aggregate spend data for that redacted data. Is that right?
Correct.
Okay, that makes perfect sense to me.
And then the non-claims based, Senator, that is consistent with the rule that we just passed, that the board just adopted last December, but it didn't specify at the time behavioral health care. And so we're using the same language that is approved in the rule, but just moving it over to statute so that there's no confusion.
That makes sense to me. Thank you for flagging those two issues. Representative Matheson.
Thank you, Madam Chair. And thank you, Ms. Harrington. Are you referring to the primary care data when you're talking about the non-claims based information? Is that what you're talking about?
Yes. So the board passed a rule that, or adopted a rule that allows or now mandates the collection, the submission of non-claims based data from the payers in aggregate, but then also specifically for primary care. We need to do the same thing for behavioral health care. And because it's not in the rule now, if you guys want us to report on that for January of this is hard to believe, 2023, putting it in the statute will allow us to do it. Otherwise, we won't have time to get the rule all updated and in place. And
yeah, that makes sense. Okay, good. Other issues with regard to Part A of the draft amendment, the discussion amendment? All right, I don't see any, so I'm going to move the three of you back into the attendee space. And I think I'm also Just going to say that I think I don't want to take up part C of the amendments today while HHS is in the middle of talking about the same exact issue. Well, not the same exact issue, but reimbursement rates is what my understanding. I got a text message from someone who's over monitoring the HHS committee. So I did just want to sort of let that committee know that we're going to need to reschedule with regard to the part C piece, but we're going to have a good discussion now about the part B private insurance piece, because that doesn't implicate the main care portions of the bill. So anybody who's sitting in our attendee list hoping to talk more about part C of the bill, you can go back to HHS and we will revisit the issue at some later point or privately and try and figure some things out between now and the next work session as well. Okay, so with that, let's turn to part B of the discussion draft. So part B is about private insurance, or I guess just insurance. It's about regulated insurance through our BOI. And I'm gonna ask Colleen to pull up a statute, but I didn't give her fair warning. So I'm gonna ask her now and then talk for a few minutes while she finds it. Could you pull up the credentialing, the existing credentialing statute for us, Colleen? And then I will just talk about where we are for a minute. As anybody who's been attending a lot of our meetings knows, we've been really pushing on this issue of credentialing. We've received a letter from Ms. Pelletreau stating that the carriers are aware that they aren't credentialing mental health professionals fast enough, but that they have some staffing challenges with regard to ramping up their credentialing process. So
I'm ready if you're ready.
Perfect. So we've talked about it on mic a number of times. I have had a number of conversations with folks who have struggled to be credentialed and therefore unable to provide mental health care to Mainers, even though they're ready, willing, and able to do so. They just aren't sure they're going to get paid, so they can't go forward. So this is the statute. Colleen, can you walk us through how it works?
Sure. So as Senator Sanborn said, these are the requirements in the Health Plan Improvement Act for health plans with regard to credentialing of providers. Under paragraph A, granting of credentials must be based on objective standards that are available to providers upon application. It allows carriers to consult with other professionals in developing credentialing standards. It requires that all credentialing decisions be provided in writing, including the ones granting, denying, or withdrawing credentials. Providers must be given the reasons, for all of the reasons for the denial or the withdrawal of credentials. A withdrawal of credentials must be treated as a provider termination, and then there are some specific statutory requirements about how providers are terminated that would then be triggered if it's a withdrawal of credentials. Carriers under paragraph C are required to have an appeal procedure for providers, including the provider's right to a hearing, to address concerns relating to a denial for not meeting the objective credentialing standards and the contractual relationship between the carrier and the provider. Superintendent is given the authority to determine whether the process provided by the carrier is fair and reasonable, and this process must be laid out specifically in contracts. And then under paragraph D, this is sort of the timeline for credentialing decisions that I think you talked about at your earlier work session. Carriers are required to make credentialing decisions within 60 days of receipt of a completed credentialing application, but it does allow for that time period to be extended upon written notification from the carrier within those initial 60 days. stating that information contained in the application requires additional time for verification. And then the total timeline is that all credentialing purposes, decisions must be made within 180 days of receipt of a completed application. And then it describes what a completed application is. Includes all of the information required by the uniform credentialing application, attachments that are required by the carrier, and all corrections. It requires the carrier to review the entire application before returning it to the provider for corrections with a list of all corrections needed. And then it does state further that a carrier may not require a provider to have a home address in Maine before accepting an application. So that addresses people that are seeking to potentially move into the state. So that's the existing statutory provisions about credentialing. And then there are further sort of requirements or process things related to credentialing that are also laid out in the Bureau of Insurance's Rule 850 as well.
Okay. Representative Matheson?
Thank you, Madam Chair. I just want to clarify. So if I understand this right, that 180 days can start after a certain point, so it could go up to a total of 8 months from start point. Is that correct, Colleen?
Just looking at it, I think that's potentially true. The Bureau, I don't have the Rule 850 in front of me, so the rule might be more explicit about the timeline. And I can stop sharing if you want, but I don't know if someone, either Joanne would raise her hand to confirm that or not, but I think that might be I'm not sure if 180, they may interpret 180 as the total, but I'm not positive.
Yep. Ms. Rawlings Secunda did raise her hand, so I'm going to bring her in. Do you want to stop sharing for a minute?
Definitely. Yep.
Great. Thanks. Good afternoon, Ms. Rawlings Secunda. We haven't seen you very much this session. Go ahead and introduce yourself.
Good afternoon, distinguished members of the committee. I'm Joanne Rawlings Secunda, and I'm the Consumer Healthcare Division of the Bureau of Insurance Director. And in answer to Representative Matheson's question, the 180, that's the total. It does not start after the 160. It's 180 altogether. So I'm hoping that gets at the question she was asking.
It does. Do you know, or does the Bureau, I know we've been talking about this and we've mentioned it to the Bureau a number of times since January on Mike, but do you have any data with regards to how long credentialing is taking for mental health providers through our insurers in Maine?
Certainly nothing specific to mental health providers. I would note that, as I think Ms. Austinfort talked about the last work session on this, that Anthem was having some issues with backlog. They prioritized behavioral health providers within that backlog because so many of the behavioral health providers are sole props or within very small practices, and they were really made an effort to prioritize that small level of practice. Mm-hmm. But I can't give you actual data as to how long it's taking them overall. I think, as I mentioned the last time, we are looking at the timeliness of credentialing within our market conduct exams. So I won't have that data obviously anytime soon, but I mean, with any luck, we would have it at some point.
Okay. Within your market conduct examinations, are you already dividing, are you looking at credentialing as it relates to behavioral health compared to as it relates to physical health, or would that just all be lumped together?
I can't answer that question. I would have to talk directly to the market conduct staff.
Okay. And is it your reading of the statute that So I should say it differently. It's my reading of the statute that it's supposed to be 60 days and that there should actually be an individualized reason if you go past 60 days, that it has something to do with that application. Is that your understanding, or is it your understanding that there's really, the insurer can just say, oops, it's going to be up to 180 days for you because we have a backlog?
The clock starts when they have a complete application. So it is more of the latter, the more of, oops, we have a backlog. They are supposed to give notice to a individual provider if this is going to take more than 60 days, but it's not necessarily because the provider has forgotten something or something like that.
Yeah, they may not have even looked at it within 60 days. And then they just say, oh, we're not going to look at it. We're going to extend it and use our whole 180 days potentially.
That is a possibility.
Okay. All right. Representative Arford.
Just very quickly, make sure I'm hearing this properly. You submit your application, you think it's complete, you're the provider submitting it. Once it's submitted, you get notice it's been submitted. The 60-day clock starts then. Supposedly, according to the statute, there has to be something amiss with that application to extend it out to the 180 days. I mean, by statute, that's the way it would work. However, what you're saying is that sometimes it gets extended because they just don't get it done, or I guess my question is, what happens if a properly submitted application that is a complete application is not completed and the providers aren't notified of the fact that they're now on board with that carrier within 90 days?
So within 60 days.
I mean, within 60 days, I'm sorry.
Yeah. Then they are supposed to be notified, and 850 is very specific about that. So if they are not notified within that 60 days, then the carrier's out of compliance.
And then what happens?
That's something that we will see in the market conduct exam, and we would act accordingly at that point.
I don't mean to belabor the point, but but I just truly want to understand, what does act accordingly imply?
These are questions that are better off with the market conduct and enforcement staff than with me. So I don't want to get out of my depth here.
Okay.
Thank you.
Representative Matheson.
Thank you for letting me ask a second question. I appreciate it. Just curious how often these market conduct reports are done.
Each carrier is supposed to have a major carrier is supposed to have a market conduct exam done every, I want to say 3 to 5 years. This is off the top of my head. And it's definitely no more than every 5 years. If there is a specific issue that we're seeing a very specific problem on, we can do them more frequently. But as far as the routine market conduct exams, it's every, like I said, I want to say 3 to 5 years.
It could, Ms. Rawlings-Sakunda, and this might be a better question for Mr. Yardley or someone else, but it strikes me that it would also be appropriate for the Bureau to follow up on complaints from providers about slow credentialing that didn't accord with the statute. Is that correct?
We technically, I mean, as far as complaints, I mean, the Consumer Healthcare Division was statutorily created to help consumers rather than providers. The way we have looked at it over the years is that we are not parties to a contract, and so therefore we have to stay out of that. Informally, we have certainly brought some provider issues to the carriers to be dealt with, but it's definitely outside of the official complaint process.
Understood. Okay. So that seems like another area the committee could potentially take a stab at with regard to credentialing, because there's no one available to make a complaint. There's no one available to bring it to your attention if you're not able to respond to provider complaints. Is that, I'm gonna bring in the superintendent because I'm asking you questions that are probably above your pay grade a little bit. So let me bring him.
Just on the question about market conduct exams, just to confirm that Joanne was correct, that with regard to domestic health carriers, the requirement is no less frequently than once every 5 years.
Okay. Thanks. The superintendent is joining us. And I'll get to you in just a moment, Rich. Representative Evans, I want to see if the superintendent has a response to something I just said when he raised his hand. Good afternoon, Superintendent. Go ahead.
Good afternoon. I had trouble with my mute button. Good afternoon, Senator Sanborn and members of the committee. Joanne is right that we stay out of provider disputes, but when it involves a statutory issue like the credentialing and timeline, it is within our purview, and that's why we call the market conduct exam. I mean, we try to prioritize resources, but when we got the level of complaints, we called the exam. Specifically, one of the reasons was because of that issue. So we take a violation of our statute very seriously, and the timelines are within 24A, so they do fall under our responsibility.
Mm-hmm. Okay, that's helpful. Representative Evans.
Thank you, Madam Chair. Ms. Rawlings-Secunda, I just had one question. How do you get your providers? Do you recruit yourself, or is it contracting? How does that happen?
Ms. Rawlings-Secunda works for the Bureau of Insurance, so I'm not sure what you're asking.
Okay, well, that's something, if somebody could, because
you're hoping to ask that of an insurer.
Yeah.
Okay.
Because, yeah.
Okay. So let's finish up our discussion with the Bureau on the credentialing issue. And I guess I'll kind of throw this out there for the committee's consideration and the superintendent's consideration at the same time, which is to say that I think it's our priority, and you know, we keep talking about access to mental health. So I'm wondering if it would make sense for us to tighten up the credentialing statute timeline framework with regard to behavioral health providers or mental health providers, perhaps even just for a period of a couple of years with a sunset provision. I'm hoping Representative Morris might smile at that suggestion, but that we would, you know, narrow that window, make it not automatic that you can go past the 60 days, and really require good cause, individualized good cause in order for anything to be extended beyond 60 days. In order to ensure that, you know, if we have a behavioral health provider who's moving to Maine or is ready to offer services in Maine, and we have all these kids who need mental health services who can't get access to a licensed provider through their health plan, you know, we need to clear that backlog and take quicker action to do that. So I'm just throwing that out there as a potential conversation. I'd love the response of the folks on the committee as well as the superintendent, if you have one.
Do you want me to respond, or?
If you're able, yes, I would love you to.
Off the top of my head, I mean, 60 days should be 60 days. There shouldn't be, absent extraordinary circumstances, there shouldn't be automatically extended. I don't think that's unreasonable. Whether 60 days is the right number, that's for the legislature to decide. But it shouldn't be a blanket exemption just because you have operational issues.
Okay.
That's my opinion.
Okay, thanks. Representative Evans, your hand is still up, but I'm not sure if you
Oh.
had a response to this issue or it was a residual hand. All right.
Residual.
Okay. Is there any further discussion on that sort of topic from anybody on the committee? Representative Brooks?
Yes, I would agree that it's important that we get as many providers helping to credential as possible during this time frame. That just the backlog and the acuity of our situation is pretty critical.
Okay, great. All right, I don't see any other hands up, and I think Representative Evans was hoping to ask a question of a insurance provider. Yeah, an insurance carrier. I don't see Ms. Awesomenfort in our meeting. Ms. Pelletreau represents an entire organization of insurance providers, so I don't know if she can answer the question, and perhaps Ms. Vanderwood represents an insurer today as well. I'm not sure if any of them wanted to make a comment or a response. They could raise their hands. Nobody's raising their hands. Ms. Pelletreau raised her hand, so I'll promote her to panelist. I'm going to keep the Bureau folks there just in case we have more questions with regard to credentialing as we proceed here. Good afternoon, Ms. Pelletreau. I don't know if you heard Ms. Representative Evans' question earlier and if you can provide any kind of response.
Did, and I will provide a more fulsome response after having consulted with the members, but I didn't want to let it slip by with no response. So the things that I would offer are that health plans are required to maintain networks of behavioral health providers. So that means the way that they get behavioral health providers is when somebody approaches them to join the network, or if they go out and solicit, if there's a major behavioral health provider in a particular part of the state that they need to meet network adequacy requirements, they will go out and solicit an entity to join their network.
Okay. And as far as the timeliness of completion from once the application is received and the eventual conclusion, what is the process for maintaining contact with that individual? It's beyond 60 days from my perspective is a long time. I just don't understand why it takes that long. Is there a follow-up if something's missing, a document or whatever? What type of a follow-up process is there to get to the completion before that 60-day time frame?
Representative Evans, that's something I need to have our individual plans respond to. What I can say is I'm sure they all try to meet that 60-day standard. And I mean, that's really what I can say today. I have posed the questions that the committee asked at the last work session to try to get some more specific information about how long credentialing of behavioral health providers is taking, but I don't have responses from the plans on that yet. One other thing I would offer that I did get from our members was that they consider providers to be a set of customers in their business. So clearly their members are customers, but their providers are also customers. So they do take customer service seriously. They track turnaround times on requests, on prior auth, and presumably on credentialing as well. The third comment I would make is in the subsequent paragraph on the credentialing statute that Colleen was sharing earlier, I did want to draw the committee's attention to the requirement that plans pay for services even, kind of during the pendency before a provider is officially credentialed. So once their application has gone, application has been accepted, then the carrier is required to pend the claims. And once they become credentialed, they would get them paid.
Right. Okay. Thank you. I appreciate it.
Thank you.
Thanks, Ms. Pelletro. And I think you've heard me say this before, but in a small practice, you can't wait 6 months for payment. You wouldn't be able to pay rent. So I think, you know, that's certainly a concern for small practices or new practitioners, and certainly a problem, even though we do have that language in place. I've heard from specific practitioners that say, yeah, I could take the risk, but ultimately they could tell me that they're not going to credential me, and then I worked for free for 6 months. So that's the rock and the hard place there, unfortunately, for healthcare providers that are trying to get into a network. It's very difficult. Okay. Are there additional questions for any of our guests on the screen at this point? Okay. So that's part B of 1196, I think, unless anyone has any other issues they want to talk about with regard to part B. We focus mostly on credentialing and not payments, because that's actually where I think the thrust of the concern was, or at least has been for me with regard to access on the private insurance side. So those are part A and part B of the bill. I promise not to take up part C because of the competing needs. Representative Matheson, go ahead.
Just wondering if part B also included the agency credentialing. Is that something that we're, okay?
No, that's main care stuff.
Okay, thank you.
Yeah. So we're holding on that until we can have the main care folks. I appreciate that Ms. Alford's still in the meeting, but I want to make sure that any of the different folks who've been involved in the discussions earlier are able to join us for that. So, so if there's no further committee discussion on part A or part B of the bill, we've asked on part A, just to summarize, that Ms. Harrington work with Ms. Shaughnessy and Ms. Alford to help us massage the statutory language, but it seems like the committee is likely to move forward with part A of the bill with some more nuanced language there. With regard to part B, I think there's some appetite on the committee with regard to tightening the timeline and credentialing. And then with regard to part C, we're postponing discussion because of HHS. Is there any further commentary with regard to that? I'm going to move our guests back. Is there any further discussion with the committee on 1196 at this point without getting into part C? Representative Arford. You're on mute.
I am sorry about that. Quickly, I'm wondering if it might be helpful to get some information on the credentialing process by statute for other states, especially neighboring states like New Hampshire, Massachusetts, to see what they're doing and what their timeframes are, just so we'll get a ballpark figure of what's going on outside of Maine. Could Colleen get that information? Would that be a reasonable request?
I think so.
Okay, great. Thanks you.
I'd be happy to. I'll focus on New England. That'll be quicker turnaround, but I can look at all states as well, see what I can find out.
Yeah, I think that would be helpful, but okay. So with that, I would entertain a motion to table LD 1196. Representative Matheson.
Move to table LD, was it 1196, right?
Okay, is there a second? Seconded by Representative Evans. And can I just see the hands of those in favor of the tabling motion? All right, it's unanimous of those present and voting. So, so with that, we have completed our work sessions for today. Colleen, do you have anything for us?
I don't have any language review for you today. I kind of caught up on amendments. I may have some tomorrow if I got some fiscal notes back, but it may be more likely that I bring language back to you next week on things you voted this week.
Okay, I think that's fine. And just as a reminder to the committee, we did add a public hearing for 10 a.m. tomorrow. And noticed at 9:59, but I doubt we will be that precise. It's just the way we notice things to let folks know that we're going to hear them first. So we will take up LD 2004 first tomorrow, and then we'll move on to the work sessions that have been noticed for tomorrow. I'll let folks know that we anticipate scheduling the remaining outstanding bills, all of them, whatever we still have that we haven't voted as of Thursday. We're going to schedule for Tuesday for a work session. And we will likely proceed in that fashion until we complete our work. That would be my guess. It's not a huge number of bills. It's, I think, 4 plus whatever we haven't voted on today, like LD 1196, and then whatever we might not finish tomorrow. My dog just nearly tipped my chair over. Okay. He's all done for the day. He just assumed his position under my desk and nearly tipped over the screen in the process. All right, so that's the plan. And that probably gives Colleen and Edna the information they need for the weekly schedule.
It does.
And I think that's it, unless anyone has any announcements. Representative Evans.
Just clarification, we're adding 2004 for tomorrow.
It's the public hearing tomorrow at 9:59 at 10 a.m.
9:50. Okay.
Yes.
I'm going to strike the 10 a.m. Put 9:59.
Perfect. All right. Representative Matheson, are you just waving us goodbye? Perfect. Okay. All right. Thanks, everyone. Have a great afternoon, and I will see you again tomorrow.
Bye.